Good day, viewers and members at home. Welcome to Labor Talks. My name is Thumele Mmako. Today we are talking about collective bargaining. And on the show we have our legal expert, attorney Modidima Mannya. Dade Mannya, welcome to Labor Talks.
Good day, and good day to the members at home and in the schools.
Collective bargaining has been a serious issue for the past 2 years. Members or workers in general, especially in the public service sector, they've been crying about the failure of government to honor the collective bargaining. What is collective bargaining and it's important for workers?
Okay, let me start it here. An employer would hire a person called an employee. Every individual gets employed individually, which means on your own volition, you see a post, you apply, you get given an offer, you accept or reject the offer. If you accept an offer of employment, you enter into an agreement with the employer. Now, in your offer of employment, you would have terms, like how much you are going to get paid, where you are going to be based, what duties you are going to perform. But the law also makes provision for certain conditions of employment, and that is the Basic Conditions of Employment Act, that these are standard. Your leave will have to be there, and all the types of leave and other conditions of employment. Now, once you are in employment, you now develop a common interest with the employer, and that is to advance the business that the employer does. Now, another person comes in, another one comes in, so you've got 200 people now employed. And these people now have a right to organize themselves into a formation, which we later call a trade union. And when they have organized themselves, then they start to gain some power, because now he has a collective of 200 people. Now the employer could deal with each one of them individually. He or she will overwhelm them. But when there are like 200 people there, they are organized now, let's say they form a trade union, they then start to interrogate their conditions of work. And they say, but are we well paid? Are we treated well? And all those kind of things. Now, once you are in that space, you now have an opportunity to say, but let's talk to the employer as a collective. Let's improve our lot. Let's improve our conditions. And the law then provides that in that situation, the employer and the employee can get involved in negotiations. And remember, these negotiations take place against the background that there's already an agreement between the employer and each individual employee. You will earn 200,000, you will earn 50,000, you will earn 400,000. But these people come together and say, no, hang on. As a group, we want to talk about how much we should be paid here. And it is in that context that they start an engagement. Now, on the one side, you must understand that when these people come together into a group, which we now call a trade union, they develop certain rights. Now, unions have got the right to organize, to represent members, and usually that is done by way of a recognition agreement. Now, this is a group of people. They say we are individual employees, but we're going to speak in one voice, and that voice is our trade union. So the trade union becomes now the mouthpiece to agitate and advance the cause of the workers. In terms of collective bargaining, that's when you now say, okay, we have an agreement about how much you pay us, but we want to negotiate that you pay us better. That's where collective bargaining starts. Now you start to have negotiations as a trade union on behalf of the members and the employer. And you initiate a process of discussing. And you come and say, employer, we think you must improve our salary. But let me indicate that, by the way, there's no obligation in law for an employer to give a salary increase. There's no such an obligation. And it's because already you have an agreement. We have already agreed. This is why you have to negotiate. This is why in the interest of the employee and in the interest of the employer, they come together and talk for the good of everyone. The employer needs the employees for the business. The employees needs the employer for the salary and other benefits. So that's basically what collective bargaining is all about. We are negotiating. Now, as we negotiate, we may agree or disagree. If we agree, we will put it down in writing to say this is what we agreed on. We agree that you are going to give us a 10% salary increase across the board or according to the following categories. And the employer can say, well, I'm giving you the 10%, but these are my conditions as well. I want you to start earlier, 10 minutes before. I want more productivity. I want us to stop, wrong things here and those kind of things. That culminates into what we call a collective agreement, which would be a wage agreement in this regard. Now, that document once signed is binding on both the employer and the employee, and it creates both rights and responsibilities on both parts. So if the trade union, which is the employees, have agreed to do certain thing in return for this 10% salary increase, they must do those things, and the employer must pay what they agreed on. If the employees don't do that, they are in breach of the agreement. If the employer doesn't do what he's supposed to do, he or she is in breach of the agreement. Now there's a procedure to deal with that. Collective bargaining is simply an engagement and negotiation between the employees and the employer on their conditions of employment.
So on the binding of the bargaining document, one will ask, what will happen to someone who is not unionized? May you please touch on that one?
In an employment situation, and as I said, 200 employees come together and all of them form a union. So you would have a 100% situation where 200 of the employees belong to a union. But you could also have a situation where 100 of the employees belong to Union A, 50 belong to Union B, and 50 do not belong to a union, because remember, our Constitution and the Labor Relations Act protect the right to freedom of association. Freedom of association means you have a right to join a union and you have a right not to join a union. But then the Labor Relations Act also make provision, because remember, then you have got a majority of people wanting a particular thing, and you have a minority that might say, we don't care whether it happens or it doesn't happen. Now, if a union negotiates, for instance, for its 100 members, and the employer agrees, the employer cannot say these other 100, because they are not part of a union, they don't benefit. Because then the employer will find itself in a situation where it's in a discriminatory practice, where people doing work of equal value are not paid equally. So basically, if a union in a particular environment were to negotiate a salary increase, say, of 10%, the effect of that is that everybody who is employed in that environment will benefit, whether they are members of the union or they are not members of the union. And that is why in certain instances you have got a situation where employers and unions have got what they call a closed shop agreement, where once the union negotiates something, it takes universal effect. Remember, those who are not members of the union can never be prejudiced, because the law will not allow, one, the employer to discriminate, two, to reduce the conditions of service.
One may ask, why should unions negotiate and bargain collectively?
The very essence of having a union and being a union is to have muscle, is to have strength. That's the fundamental basis. Now, remember, there's this saying that united we stand, divided we fall. As I said, if an employer were to deal with each individual, if we were to negotiate individually, so I'll go to my manager and say, well, I think, look, I'm doing very well. I think you should give me a 5% increase. He says, yeah, I'm giving you 4%. And then I leave. So my contract, or my individual contract of employment will be amended to reflect the change in the salary by 4%. You go to your manager And you say, I think I'm doing well. He says, not, I don't think so, and you're getting nothing. We have an agreement with you. Please leave my office and go and do your work. Somebody will get 6%. So it will be a differential situation. Now, it's not even good for the employer, because tomorrow I pick up, oh, okay, this one was given a 4% salary increase. I'm not getting a 4%. Now, even in terms of the working environment, it has got a detrimental effect. So the whole essence of coming together is to protect each other and protect the employer. The employer, by engaging with the union and negotiating, especially in good faith, is also protecting itself, is protecting its employees. So it's very important to have a strength, to have the muscle to engage with the employer.
At what level should collective bargaining take place?
When a union represents a number of employees, and when there is an agreement that the union is recognized, there's what we call organizational rights, which include the rights to collective bargaining. Usually there are thresholds. There are unions which would not reach a threshold of 50+1, for argument's sake. So they wouldn't really be able to represent everybody. You only represent a majority. You need to have a majority. But then the law also provides for things like what we call workplace forums, where, for instance, the union would not meet the threshold to get recognition, but it would still have certain rights.
The process of bargaining in good faith and bad faith, may you please clarify that?
When you bargain, obviously, this is a relationship issue. And that's very important, because the question of whether this is in good or in bad faith is about the relationship between the trade union and the employer. And when I talk about the relationship, I'm not saying that the union and the employer are buddies. They are not friends. They represent different interests, but they also represent a common interest. An employer that has got the interests of its employees at heart will always do everything and anything to create a harmonious working relationship. So that's where it starts. Now, when we talk about bargaining in good faith, is just to use a practical example. If the employer says, I'm running at a loss, I can give you a salary increase, naturally you would say, well, show us the loss. Somebody who's acting in good faith will be transparent and put the books on the table. If somebody says to you, well, I'm running at a loss, when in fact they are not running at a loss, they are not acting in good faith. If the employer seeks to divide the workers, wants to give others benefits as part of trying to weaken the strength of the workers or the union, that is not good faith. If the employer withholds information, if the employer gets involved in underhand tactics, that cannot be good faith bargaining.
Between two parties in a relationship, to negotiate an agreement as part of the process of collective bargaining, why is it important?
Remember, the government had an agreement with labor in the PSCBC, a 3-year wage agreement. And the agreement was implemented in the first 2 years. And in the 3rd year, the government then said, look, we don't think this agreement is proper. We don't think it's affordable. And they approached the court to have the agreement set aside. And the matter ended up in the Constitutional Court, which actually set aside the agreement. Now, let's go back to where it started. It started with a previous wage agreement that came to an end. And the process of negotiating a new agreement starts. Now, when this process of engaging on a new agreement starts, the employer knows where it stands. It knows what it's capable of providing. It should have ordinarily done research. It should have ordinarily given its social partner, the trade unions, all the information to say this is where we stand. Now, if 2 years later you come back and say, well, I don't actually have the money. In fact, I shouldn't have entered into this agreement. Even if you have the correct legal basis to make that, but it doesn't give a sense that you acted in good faith. It doesn't engender mutual trust. You can't trust that if we sign another agreement, the employer is going to comply with the terms of the agreement. They've already shown that they are capable of residing from an agreement. Now, in law, we always say agreements bind us. And in law, we say when you enter and sign into an agreement, you are conscious of what you are doing. And I'm not saying there can't be errors, but I'm simply saying that the error cannot be such as to reverse the entire objective of what people were talking about. Remember, negotiations is a give and take. People sit here and they say, the unions say we want 15%, employer, no, we can give you 3%, and they engage, and then employers say, okay, let's improve this to 6%. The unions say, well, look, we are only prepared to drop our demand to 10%. Now, it's a very intense process, and it's not something that you just wake up and say, well, I'm giving you 6%. It means you would have done some work, you would have applied your mind to this issue, you would have followed certain processes. So it is in that context when we talk about good faith, we talk about mutual trust. And if trade unions and employers enter into agreements, and one of them, even if it was a trade union, if they don't comply with the terms of the collective agreement, they undermine the relationship of trust. They are not acting in good faith. The same applies with the employer. So put the legalities aside and talk about what creates a relationship between the trade union and the employer.
If both can't reach an agreement, what must happen?
There is no obligation to reach an agreement. The employer is not obliged to agree to your demand or your proposition of a salary increase or improvement in the conditions of service. As I said from the beginning, there's no obligation to give a salary increase. Now, what the law provides is that when that happens, where we can't agree, obviously, I want 6%, you want to give me 2%. Well, I don't accept your 2%. When you don't accept my demand for a 6%, it means we have a deadlock. Now, how do we break the deadlock? And the law makes provision for what is called a conciliation process. Now, the conciliation process will now bring in a statutory bargaining council to try and break the deadlock and try to get the parties to find each other and to mediate. Now, the parties will engage in that, but remember, they come with their positions. It may as well be that through the intervention of the bargaining council, the unions say, okay, let's drop our 6% demand to 5%. And the employer says, well, look, let's move a bit notch up and say we will give you 3%. And ultimately, through the facilitation process, they ultimately say, well, let's settle for 3.5%. Then they can reach an agreement. But let's say the position stands rigidly as they were, there won't be an agreement. Now, that is the moment where the workers must make a choice and say, we need to put this employer under pressure to accede to our demand or to at least move. And this is where the facilitator, which is the statutory bargaining council, will say, look, we have tried to reconcile you, we have mediated, we have tried everything, you don't agree. Now, here is a document that is proof that you don't agree on your demands or offers and counter offers. The law then makes provision that you can now go on strike. Obviously, you would now have to follow certain procedures, like you give notice, you have the picketing rules in place, and all those kind of things. So that is the statutory mechanism or the legal mechanism to put the employer under pressure. So you may, for instance, say we are withdrawing our labor, which is what a strike is all about. You withdraw your labor, the employer thinks, okay, I can't serve social grants beneficiaries. This is going to cause social discord, you know. I don't have people to pay pensions. I don't have people to admit people in the hospital. I don't have teachers to teach children in the schools and all this kind of, I can't afford this. Let me go back to the negotiating table, you know. And the employer, if, for instance, the state says, okay, they withdrawing their labor, the law authorizes me to lock them out, which means I'm basically preventing them to come to work. I'm not going to pay them a salary. And that is where things like no work, no pay comes in, you know, where people have not rendered a service, so they will not get paid.
Let's go back to 2018 collective agreement.
Yeah.
What really happened to that agreement?
Look, as I understand it, there was a signed agreement, but for some reason, it appears that the entire process on the side of the state was not properly followed. Because as it turns out, the Minister of Finance is the one who took issue with the implications of the agreement and is the one who ultimately secured a court order that set aside the agreement. Now, as you know and you understand how the government bargaining system works, that the government has got a mandating committee. And the leader of the negotiations in government is the Department for Public Service and Administration. What one doesn't understand is how the department authorized the signature of this agreement if all the processes within the government were not followed. But as I say, that ultimately turned out to be one of the main legal reasons why the agreement had to be set aside. Then there was also the issue of the cost of the agreement. Again, as I say, when you go into negotiations, you know, you come with clean hands. You provide all the necessary information. And one of the reasons why it's important to put the information, all the information on the table, is that you also protect yourself. In the event that you have missed something, the people you are negotiating with will ask questions about this information. And the question is whether all the information in the first place was put on the table, whether all the authorizations were obtained, because again, it's very discouraging, as I say, it affects the relationship because now for instance, now we have got the last wage agreement negotiations, which ended up without an agreement. And no doubt that what happened to the 2018 wage agreement had a bearing on the attitudes in the negotiations. But you can also see, I think from a policy point of view, that there's a change of direction on the part of the state, because repeatedly you hear this very serious policy statement about reducing the wage bill, you know. So it's clear that there is a policy in government that says we must reduce the wage bill. And I think that means the scope of negotiation gets a bit narrowed to what? And I think you would have seen, I think it was last year, there was no signed agreement. But as I said, there's no obligation to grant a salary increase, and it's a discretion of the employer. Now, what the state did was to say, well, we don't agree with your proposed salary increase, but we nevertheless believe that we must get an increase. We will decide how much we give you, and they then give you that salary increase, which we call a unilateral implementation. We call it unilateral because under normal circumstances, when you are involved in wage negotiations, you will have a wage agreement, which then represents the collective view of the parties, that is the employer and the employees. So and because there's no obligation to give a salary increase, and there's no obligation to agree, the state decided we are now going to just give it to you. It's in our discretion. Whether the unions agree or they don't agree is no longer relevant. The negotiations have not yielded anything. The employer decides, and that's the same thing that a private sector employer could do. They could just simply say, well, we don't agree, but we think it's necessary to give you some increase. We give you 2% and we implement it.
On the implementation part, what is the process for a government to reach that part of implementing it without consultation?
Well, remember, we have reached a stage where we don't agree. The negotiations are over because we don't agree. If, as I said, if we agree, we sign a collective agreement. If we don't agree, go back to your work, I go back to my office, and that's the end of it. So the decision to implement is not the collective decision. The government didn't even have to consult the unions because they have said to them, look, we don't agree. They may as well have said, we are not even giving you anything. So it reverts back to the original position before the negotiations. There was no increase before the negotiations. Now we have the negotiations, we can't agree, the position goes back. The government then sits on its own and say, well, we didn't agree with them, now we decide, but nevertheless we are giving them 2%, so we implement 2%.
So we had a situation where union like SADTU was blamed for agreeing to that percentage which government gave. Is it possible or for a one union to agree, for example, we don't say SADTU agreed. Is it possible for one union to agree to a certain percentage, then others say we don't agree with this, but government continue to implement?
You can't even say other unions disagreed because there's no agreement. That's the bottom line. The decision that the government took is not a decision based on collective bargaining. It's a decision that the state took as an employer. So to say that certain unions disagreed and other unions disagreed with what? Because if the government had come and said, we have disagreed with you on what you say you want, right? Now we are tabling our decision to implement, say, 3%. What would you expect the unions to do? To say, okay, we are agreeing or we are disagreeing? They didn't have to agree or disagree. This was a unilateral decision of the state. People may have expressed their views about what they think of what the state wanted to implement or not implement, but there's no way you can say this particular union disagreed. Disagreed with what? And you can't say this union agreed. Agreed with what? Because the collective bargaining process had reached a dead end. The next stage was if there was to be industrial action, for instance. That would be the logical step after the disagreement.
If the government can go ahead and implement the decisions, what does this say about the collective bargaining?
There are two things to it, as I said. First is the relationship that you build with the people that you deal with. The second part is the legal rights part of it. Now, legally, the government would have the right to do what it did. But in terms of the relationship management, what are its implications? You must remember that the relationship between an employer and a trade union is not only limited to wage negotiations. It's not only that. If you take an example of the situation we found ourselves in of COVID-19, it had nothing to do with money. But a trade union is a social partner of the employer. So even if we don't talk about money, we still have to have a genuine and meaningful relationship. Now, let's say for argument's sake, and let me give this example. You know, in Zimbabwe, a few years back, the government could not even pay salaries. Okay? Now, you would have needed, and if it was in South Africa, the workers would easily go on strike without being harassed by anybody. But it is also possible that the government would have said to the workers, look, we are in this precarious position and public services must continue. Are you, as a social partner, can you come with us as we navigate through this challenge? In a proper situation where you have a relationship based on trust, not antagonism, the workers are likely to say, fine, we understand the problem and we want to be part of the solution. So the point I'm making is that the fact that you have got a right as an employer to act unilaterally does not necessarily help in building the mutual trust relationship that you need with your social partners, because the issue of this wage negotiation is not the only thing that you relate to. There are a host of other things. For instance, you could easily have a situation where you say, in law, I have a right to implement. And then you have a situation where you need workers to work, for instance, longer hours. Now, the law would say they should be paid overtime, okay? And you don't have the money to pay overtime. So you appeal to their conscience, isn't it? But they can also throw the law back at you and say, okay, in law, we are not obliged to work overtime. You know, the law says when people work overtime, there must be an agreement. So they can adopt the same approach and say, I don't want to work overtime. I'm not obliged to work overtime. You can't punish an employee who refuses to work overtime because in law he's not obliged to work overtime. So you will have a very legalistic approach to a relationship. Now, naturally, don't expect that you use the law to benefit and expect others to use morality. So if you destroy the moral relationship, you want to make it too legalistic, you must expect that the other side will respond, reciprocate. You know? So you might as well find a situation where tomorrow is the government or the employer needing the unions say, well, in law, this is our position. What will the government do?
Greetings, comrades. With the advent of social media, SADTU has evolved with the times to bring you the educator's voice on your social media platforms, to report on issues regarding your conditions of service, union programs, and to highlight the successes of members who excel in the profession, and many more. This is SADTU Online TV, coming live from Matthew Koniwe House. This is Nomusa Cembi, your host. Amandla.